Hey, friends and clients of JLW Immigration Law Group. I am Jennifer Walker Gates. I'm here today in this video to share with you the documents that you need if you are a U.S. citizen filing an I-130 on behalf of a parent. This is one of my favorite types of cases when one of our clients becomes a U.S. citizen and can finally file that petition for their mom and or their dad to come and live with them in the United States. This is a big step towards reuniting families, and it is such a joy. And I really hope that this video is helpful for you if you are one of those people. Now, it's important to note this only applies for U.S. citizens. Unfortunately, lawful permanent residents are not eligible to file I-130 petitions for their parents. So you have to become a U.S. citizen to do that. Or if you were born in the United States, you may also be eligible to petition for your parents. So if you're doing that and you're in the process, this document will help you, I hope. If you would like a copy of the document, we're happy to share it. We'll put our email address below this video and I will go over it multiple times. It is info@jlw.law. Send us an email at info@jlw.law. Just in the subject line, so you want the document, I-130 documents required for U.S. citizen filing on behalf of a parent, and we'll be happy to send that right back to you. So with that, let's take a look at the document itself so I can explain what I'm talking about. So here it is. Here is our list of items required that we provide to clients who are U.S. citizens filing on behalf of a parent. In a case like this, as you can see, there's a child who is the petitioner, okay? And then there's a beneficiary who is the parent of that child. Now, this child has to be at least 21 years old. So technically they're not a child anymore. Biologically, they are, legally, they are an adult, but rather than call them adult, we're just going to call them child and parent. Okay. So in this case, every type of immigration I-130 requires birth certificates for the petitioner and the beneficiary. This type of case is certainly no exception. Not only is a birth certificate proof who the beneficiary is, who the petitioner is, but it should also prove that family relationship. Now, children can file for step parents as well. And so a birth certificate may not do everything to prove the family relationship. That would require marriage documents as well, but we'll get to that in a moment. Suffice it to say, in terms of identity documents, that birth certificate is going to be necessary for both the petitioner and the beneficiary. Now, if the child has a U.S. passport, you can provide that as well. If they have become a naturalized U.S. citizen, you can provide that as well. A driver's license is what should be going in this field right here. A driver's license may be helpful for proving identity, not always required for immigration, but can be helpful. So, and if there's something else that makes sense to include in this section of documents, please add it to this list here. You can fill in the child's name and the parent's name here, and it will populate all through this form. And so for the parent side, the identity documents that they are going to need is going to include a passport and a birth certificate for sure. Now, these other items may or may not be included. They're not always mandatory. It depends on the case. So if they are in the United States or have ever been in the United States, showing their lawful entry can be helpful, but lawful entry may not have happened and it may not be required in your case. Having a visa, same thing. They may or may not have one. A work permit, same thing. May or may not have one. If they do, great, include it. If they don't, it's okay. You do need to get your case analyzed for eligibility, but presuming you already know you're eligible, for sure the passport and birth certificate are going to be important. All the rest of it may be optional. When it comes to family relationship documents, if the petitioner is married, then include the marriage certificate for the petitioner. If the beneficiary, the parents, are married or have been married, then providing their marriage certificates and or divorce decrees is also going to be really important. Now, there are divorce decrees and death certificates and annulment decrees and marriage certificates all listed here. Suffice it to say, anyone who's been married or divorced, whether that's the child or the parent or a stepchild or a step parent, if that is the type of relationship, everybody's going to need the marriage certificates, divorce decrees, birth certificates. These kinds of relationship documents are critically important. And so even if you have never been married, but if your parent has, you need to include it. If they haven't, obviously, ever been married, if neither party has ever been married, then this won't apply. But if they have, and there's ever been a divorce or anything on either side, all of that stuff has to be provided. Annulment is what happens when a marriage takes place, but is later found to have been illegal from its start. So let's say a person finds out that the person they got married to was underage when they got married. That kind of marriage can be annulled, meaning it's just wiped out from the very beginning. It's not like a marriage took place and then a divorce ended the marriage later. An annulment means it goes all the way back to the beginning and erases the marriage from the very start. If this is a child filing on behalf of a father who was not married to the child's mother at the time of the child's birth, then some additional steps may need to be taken to prove that relationship. A DNA test will take care of the entire issue. It is an additional expense. And so you may want to try to prove up that family relationship without a DNA test. If you want to do that, you can use family photos of you and your father together, the child and the father taking trips together, spending time together at family gatherings together. Those kinds of photos can be helpful. And other proof of parental support or financial support can go a long way. So you may have statements from friends and family. You may have receipts showing money transfers. You may have some kind of proof of child support. You may have some other kind of proof of the parental relationship if you're dealing with a case where the petitioner is the child of a father who wasn't married to the mother at the time of the petitioner's divorce. USCIS really discriminates against fathers in this kind of case. Mothers typically don't have to go above and beyond to prove a relationship. They let the birth certificates take care of it, but for fathers, they do require a little bit of additional supporting evidence. I hope that these videos have been helpful. Again, if we can help you file your I-130 on behalf of any family member that may be eligible for you to do so, we're happy to help. This is, again, the first step towards reuniting your family. It's a really important type of case. Please reach out to us. You can find us online at jlw.law. And on our website, you can click to schedule an appointment directly on our calendar, or you can find our phone number and give us a call. We'll be happy to schedule an appointment for you to talk to one of our attorneys about how to file an I-130 successfully so that you and your parent can be living in the same place again. I wish all of you the very best. Again, share, leave us comments, give us a like, and come see us on social media, and we'll be happy to see you there. Take care, everybody, and we'll see you again soon.